All right, y'all, we're back at it. Now, don't tell me I got too much sun. I've been hearing that all day. It was the tennis again. And I'm a little jet lagged, but I didn't want to hold back this episode because I left you with a cliffhanger at the end of the last episode. We're talking about estate planning, and I did save the best for last. So let's just get right into it. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. Part 1, quick recap. Recall that we talked about the ever-popular doing nothing. You cannot beat the price on doing nothing, although your heirs are not going to appreciate it, but that's certainly an option for you. And it's an option, incidentally, that's exercised in a great part of the world. Most of the world that I'm aware of, those rules are set by statute, and there's not a lot you can do about it. The United States is very different, however. You have a great deal of control over your own estate. So you may want to take that into consideration, but doing nothing is an option. And then, of course, we talked about having at least a will, which really everybody should have at least a will. And that's nice. I mean, it gives you some control over like your healthcare, for example. You can put healthcare directives in there, and it gives you some limited control over your personal belongings and even some of your real estate to some small extent. The disadvantage, of course, to having just a will is that anything that has a title like real estate or boats or vehicles, things like that, I mean, you're going to need somebody who has authority to sign off on the sale or disposition, whatever it's going to be, of that thing. So your heirs are going to be required to go through a probate in order to get an order from a judge because you're not around to sign anything. So that's where we left off last week. And now let me just hit on one other thing before we get to our headliner. Part 2. There is something in between, the full estate planning that I'm about to get into and doing nothing or having just a will. You could, if you are in a situation where you have, say, one property and maybe not a ton of assets, say below $75,000 in other assets, maybe you could do a specialty deed that would pass along the property without having to go through a probate. Now, if you hearken back to our episodes regarding specialty deeds, then you'll remember we talked about a ladybird deed. We also talked about a deed where, say, you put your child, say you only have one child, you put that child on the title along with you and give that person a right of survivorship. Either of these solutions, preparing one of these deeds, would have the desired effect of causing the real property the title to that property to pass to the indicated person. Doesn't have to be your child, it could be anybody, but whomever you want, it could pass to that person without having to go through the courts. And that could be very efficient, and it could be perfect for your specific situation. That's possible. So then you might be thinking to yourself, okay, so I'll just do one of these specialty deeds for my house because I just have one house. And maybe I'll do a will as well so that my healthcare directives are taken care of and, my personal belongings and things like that. And I'm good. And the answer to that is maybe you are. If that's the extent of your estate, that might do it. But then you might also be thinking, okay, let's say I have 2 or 3 investment properties. Why couldn't I use the same technique? I'll just do 2 or 3 specialty deeds. I'll set up a will, and I'm still going to get out for less than it would cost me to do a full will and a trust combo. So why not do that? Well, it would work for your purposes of estate planning, but let's not do that. That's not a good idea. Don't do that. Once you have 2 or 3 investment properties, you have assets, and you should be thinking about how to protect those assets. So even though for estate planning purposes that might be perfectly effective, and it makes no sense at all. Don't keep 3 investment properties in your personal name and have them exposed to your creditors. Let's not do that. You'll bring the trolls right out. Part 3, we've come to the main topic of the day. If you are watching this video, more than likely, this is the solution you're going to want to go with. It's the pour-over will, so-called pour-over will, along with a trust, probably a revocable trust. It's that combination that you're going to want to set up. That's kind of the, basic full estate planning. Maybe I shouldn't say basic. That's not perhaps the right word. It's the foundational estate planning. Having that combination of a will and a trust, you can build off of that depending upon the size of your estate. and what it is you have going on, companies, investment properties. You can do these things in layers, but it all starts with that combination of the will and the trust. So let's get into that just a bit. Let's get into some basic features here. So let's start with the will. Anything that is not financial in nature, not directly financial in nature, you're going to put in your will. So, that's where your healthcare directives go. You're going to name a personal representative. That could be handy as well. You need somebody just in case. Although we're probably not going to be going through probate. We hope not to be going through probate. But still name a personal representative just in case, along with your healthcare agent. And then the primary clause, the biggest provision in your will, if you have that combination, is the pour-over clause. And that says, look, everything belongs to me personally at the time of my death pours over automatically into my trust by operation of law. No need to go through a court. I don't need a judge to issue an order. It just happens automatically. And that is why we call it a pour-over will. Very important concept. Now, why do we want everything in your personal estate, your personal belongings, to pour over into the trust? Okay, we do that because in your trust, that's where you're going to put in all the stipulations. That's going to be your main vehicle, your primary document that controls who gets what, under what circumstances, under what time frame. That's going to be the more detailed document. Okay, so what are the key features to this trust that we're talking about? And of course, there are lots of different types of trust, but this estate planning trust that we're talking about that works in combination with your will, key features, well, like any trust, are the trustee or trustees, and of course, the beneficiary or beneficiaries. Plus, I should add the fact that a trust is an entity, like a company. It's similar in that sense, and entities don't die. You die, the entity continues, and that's how we can avoid probate. So when you pass away, that pour-over provision is going to kick in. All your stuff then goes automatically into your trust. Your trust continues, and now the trustee that you've named to take over once you pass away, or even, once you're not willing or able to manage your own affairs, that trustee then will be the person who's in charge of following your wishes, everything that you've set out in that trust document. So in a way, you've replaced the judge's function in a probate action with this person that you've chosen to act as your trustee. And I guess that really is the primary difference. Once you set up a trust, now you have something that's going to survive you, and you can set it up however you want. You have an incredible amount of control. Not only do you get to name your trustee, but you can name a co-trustee, or you can name an alternative trustee, a successor trustee. So let's say, your trustee's not around, doesn't want to do it, or predeceases you, God forbid. Then you have your backup ready to step in. You can even create a board, board of trustees. So, it takes more than one person to make decisions about how the assets are going to be managed or dispersed. There are also professional trustees. They tend to be pretty expensive, but they will, there are companies that's what they do, trust companies. They will manage your assets. They will continue to, invest, collect rents, do whatever, just as though you were still here. Your enterprise, your empire that you've set up will continue to function, and you can then have those profits distributed however you want to your beneficiaries, for example. So as you can see, there's a full range of how you use these estate planning trusts. It could be anything from as simple as, when I pass away, all my stuff goes into the trust, and here's how I want it to be dispersed. And once you disperse it, sell my properties and give the cash to these people, in these percentages. And then once that's done, trustee, your work is over. Just terminate the trust at that point. That's very common. You could just do that. Or maybe there are other circumstances where rather than terminating the trust, you'd rather have somebody stay in position as a trustee. Maybe you have somebody with special needs, or just somebody you don't trust to spend the money well when you're not around. So you want a trustee who's actually going to be in charge and just doling out, support as the trustee deems fit. You can hang all kinds of conditions on anything and everything. It's your stuff, so you get to make all the rules. So you could be like, my kid, he gets his college paid for through the trust, but he doesn't get disbursement of all the assets unless and until he graduates college. You know what I mean? For example, stuff like that. Trust also gives you a good amount of control when it comes to things like spouses whom you don't know, or potentially of whom you don't approve. You can make sure that nothing goes to that spouse, say in the case of divorce or just otherwise. You can even skip like a generation and have things go to your grandchildren rather than to people at that first level that maybe you'd rather you know what I'm saying. You don't want them to get anything. Actually, while we're speaking of beneficiaries, just the same way as you can name a successor, an alternate trustee, you can do the same thing with beneficiaries. You have some greater control over, let's say you have multiple beneficiaries, more than one child, just as an example. You can decide whether should one child predecease, God forbid, then what happens? Does that child's assets then go to his heirs, or does everything vest in the remaining beneficiaries? See what I mean? See the distinction there? You have control over things like that. Yeah, all right. What other wonderful things can I tell you about trust? Because I really love these vehicles. They're amazing. As we were saying, you can avoid the probate action. You can have essentially perfect control over your estate once you're not here. What else can you do with them? So other uses of a trust. Remember, it's just the backbone of your enterprise. It's the most important thing, and it helps you avoid going through the courts or your heirs going through the courts. And so that's kind of its primary function, but you can do so much more with it as well. You can build off of your trust, your estate trust that's at the top of the pyramid. You can have an LLC under that, or companies, corporations. You put all the shares of the corporation in the name of the trust, and now the trust is the owner of the corporation, not you personally. That has some asset protection benefits. It also is very streamlined, right, in terms of how to administer your estate when you're gone. If everything belongs to the trust, then everything is subject to the provisions of the trust. You've resolved everything in one fell swoop. With one document, you decide what happens with everything. Just one more level I'll mention briefly, because it does really go in stages here, or tiers. That's a better term. Your main trust at the top, let's call it your estate planning trust or your family trust. And then below that, you're going to have your LLCs and corporations. You're going to have your businesses at that level. And then below that, you may have, let's say, investment properties, for example, or company vehicles, right? So those will be owned by, depends. If it's an investment property, maybe you want to use a land trust. That's very efficient. You should probably look into that. If you haven't, check out some of my previous episodes. So you see what I mean? You can build this thing in tiers, and it's very streamlined when it comes to taxation, and it's also great when it comes to administering your estate when the time comes, because everything is governed essentially by one document. It's just a beautiful thing, and along with that, you're going to pick up a great deal of asset protection as well. So just to wrap things up, I do sometimes get asked about using a trust like a U.S. trust for foreign assets, or maybe we put it this way: your estate planning here in the United States. When you have assets in other countries, to what extent can you control foreign assets through your U.S. estate planning? And for the most part, the answer is not very much. I mean, I don't pretend to know the laws of all the world, all the other countries. So, don't quote me on this, but in reality, you probably are going to be stuck with just your U.S. assets being controlled by your U.S. estate planning documents. And I do think that there are some exceptions to that, just from talking to people, other attorneys. But I know that a large part of the world, in Europe and in South America, maybe Mexico is different in this regard. I was just talking to a Mexican attorney, and he said that they have a good bit of control over their patrimonio, their estate, like we do here in the United States. However, it is common in foreign jurisdictions. I'll speak to Spain because that's the one I have the most knowledge about. That your state is governed by statutes that are set by the country, and the judge doesn't really care. It would probably be a notary, in fact, a notario. Doesn't really care what you've put on paper, how you've set things up. They're probably just going to pierce right through that, set all that aside, and follow the statutes. For example, I think the idea is that you're not allowed to disinherit your kids. Or whatever, whoever your next of kin is. You're limited in your ability to disinherit people in many countries in the world. But that is not the case in the United States. You can do things very efficiently. You can do things in the way that you want to see them done. And you can do things in a streamlined and asset protecting way. So take advantage of that fact. Como siempre, recuerda que hablamos español. And don't forget to tickle the algorithm down there with your likes and comments. And folks, I will see you next week. We're out.